The next barrier is, well, and again, I hate PowerPoint because it forces you to oversimplify, but there's really no law in the field of child custody and visitation. This is, again, a slight exaggeration, but what that means is there's no clear statutory definition that helps define what the best interests of a child are. So in, I think, Canada and certainly in the United States, there in the statutes it says it is in the best interests of the child to have frequent and continuing contact with both parents regardless of marital status. And that's pretty much, I think, the standard for most Western jurisdictions. There is no such statutory definition in Japan. The Japanese Civil Code simply says that upon parental separation or divorce, a judge will decide what's in the best interest of the child if the parents can't decide by themselves. So it comes down to being an administrative decision on the part of the judge. And in fact, the dictionary definition of the decisions that Japanese family courts make in these sort of cases is an administrative decision in the absence of actual law. Similarly, there is no system of guardian ad litem or independent representation for the children when parents are getting divorced. You can't even go out and try and hire a lawyer for your child to represent them independently, to make their voice heard. So this leads to an interesting situation where the lawyers for both parents purport to be asserting things that are in the best interest of the child when they're not actually representing the child. There is no joint custody in Japan, so certainly one of the problems that foreign parents have is they may show up with a custody order that says joint custody or joint residence or whatever it's called in the jurisdiction that they come from, and there's no way of processing this because Japanese law doesn't recognize formal custody. I haven't ever seen it written that you have a right to know where your child is. And that also is a problem because parents show up and they actually don't know where their child is. They go to the police box and they're told, well, it's a civil matter, we don't know, your problem. There is no visitation. There is actually, visitation is something that is not even in the statutes and was effectively created by judges. It is not a right in the commonly understood sense of the word because it's not enforceable. There are very few remedies for parents, even if they do get visitation in a court proceeding, and it is increasingly being awarded in divorce cases. It's just not something you can enforce. And again, in Canada and other places, the police or the marshals or some law enforcement official with a gun, in the absolute worst case, will get involved in enforcing a court's custody decision or even access rights, but that is not the case in Japan. Actually, my own view is that visitation is a right that exists primarily to be terminated to the extent that it's a right, because if you look at the list of reasons for having visitation terminated, if it wasn't sad, it would be funny because, examples of things that can get your visitation terminated are buying too many presents for the child. I know of a case of a man who had his visitation terminated because the thought of her children seeing him made the mother physically ill. A solution, don't see the father. Just there's a very long list of what seem to be extremely trivial reasons for terminating all parental access, which for some reason don't apply to termination of custody. Foreign law and court orders, as we've sort of got a hint of from Murray's case, are generally ignored when it is inconvenient, or they're respected in word but not in enforcement. If I could have the next slide. And part of this, and I just want to make clear that, I'm not saying a lot of, we said this wasn't going to be a Bash Japan night, and part of what I have tried to do in my research is come up with a theory for why the Japanese system works in these cases the way it does, when everybody's actually really nice and well-meaning, because I actually do think that most of the people in the Japanese family court system, in Japan generally, are nice, well-meaning people who want to do a good job and help. So why do we get these results? The next barrier is, and if you're a lawyer, you know that procedure is often more important than actual law. The next barrier is procedure. Family courts in Japan have this system of mandatory mediation, and this is actually a widely praised system, which is, instead of immediately going into sort of adversary litigation mode, you have to go through mediation. It's a good system. The courts in other countries are actually trying to emulate this. The problem in Japan, though, is 90% of the people who can talk through their problems have already been filtered out of the system, because most people in Japan get divorced without ever going to court. It's actually one of the easiest places to get divorced in the world if both parties are agreed to it. There's a form, you fill it out, you seal it, you hand it into the government office, and you're done, you're divorced. Not only that, there's a form, there's a place on the form which says which parent gets custody of which child. So you can make that decision all by yourself, and nobody cares. It's automatically assumed that if the parents agree to it, it's in the best interest of the child. So once you take those people out of the system, well, who are you left with? Well, the people where at least one of them, or possibly both of them, are probably unreasonable, and then you're imposing upon them this requirement that they talk. In the context of trying to actually see your child, this can actually be used as a delaying tactic, because you want to see your child, well, let's have mediation. How does mediation work? Well, you go to the court once a month, and you mediate, and nothing happens. And then they make it schedule for the next month, and you do it again. Repeat until one or both of you are tired of mediation, or you could agree to something, but during that period, nothing happens typically. There is no interlocutory, to use a legal phrase, remedy where, well, we will let you see your child, we will order that you be allowed to see your child while these proceedings are in place, because, well, in the context of visitation or access, if you could see your child, the mediation would be pointless, right? So mediation actually prevents a lot of sort of prompt remedial action from taking place, because you only get to sort of a real court where there's adversary proceedings after the mediation is declared ineffective. There are exceptions sometimes, and in fact the only remedy that Japanese courts have in these cases where there's sort of a hint of maybe law enforcement will get involved is habeas corpus proceedings. Now I know you're thinking, habeas corpus, isn't that what's going on in Guantanamo Bay with the American Supreme Court and the people who've been held there for 5 years by a government agency? Yeah, the same habeas corpus, except in Japan it's used in child custody and child abduction cases, parents against each other.